I'm just kind of hoping that, like, I don't know, because I'll be gone for 3 weeks. So I'm hoping that maybe, like, they'll put the measures in place, you know, like for like 2 weeks, 3 weeks, like, I don't know. And then, like, when I come back, then, like, I'm sure there will still be measures, but that, like, yeah. And, like, that they'll keep, like, school open and stuff.
And my legal history exam will still be held offline,
Mm-hmm.
to my knowledge, but for criminal law, there's no news.
Mm,
Yeah.
that's hard.
Yeah. Did you take the exam online?
Yeah, we had all of our exams online last year.
Oh, right. Yeah. How was it?
Well, they were all open book, so it wasn't so bad. It's kind of weird. I don't know, because, like, you get so used to, like, taking, like, standardized tests, where it's like you're in an exam hall and you're with everyone, and, like, you can just kind of, like, I don't know, enter that mentality. And then if you just take an exam, you're, like, sitting, like, in your room, like, alone. It just, like, feels different.
Yeah.
But the actual, like, taking them, like, once the exam starts and you're, like,
Yeah.
like,
Yeah.
then it's, like,
Yeah.
basically the same. But I'm actually gonna try and, like, maybe put this here, because I was like, my friend was teasing me about, like, putting, yeah, like, she was like, you have it right here, and I was like, I know, it's just like, just how, like, the cookie crumbled. And she was like, this is the worst, like, you could not have chosen a worse. And I was like, you're telling me, I'm the one on, like,
Yeah. But I
So
feel like
I was like, they're just, it's the content,
Yeah.
And then she was like, sure, but
it would be nicer
if I looked like a
Yeah.
marginally better. But then I need to stay close to them. You see, there's, no, it's kind of good. It's just, I have to be close enough to the microphone. The form is loud, like,
Yeah.
it's fine. So I'm just gonna talk to Noah. Give her, like, one more minute. Because she said she was almost here.
We're going to talk about the materials in week 5, right?
Yeah.
Okay.
Yeah.
Because in your PDF it says week 3, perhaps you were mistaken.
Oh, I mean, it's like week 3 of tutoring.
Oh, okay, yeah, okay, great, yeah, that makes sense. But I don't think we have the last case. I cannot pronounce his name. Versus Germany.
Chakshavili?
Yeah.
Yeah. I don't think so.
Yeah.
It's because I don't have the syllabus. Hi. So I just, like, kind of make these, like, but also they told me, well, yeah, I sent you guys notes this morning because they told me that part A was switched. So, like, the material that I have there now is what you guys will do next week.
Okay.
And then,
I'll take
but, yeah. Okay. So we'll start, of course, with part A, as per usual. Do you guys have any questions that you want addressed? Like,
Mhm. Objective and subjective.
okay, like anything in particular, like when it's used, or like what it is, or
As it changes for like with the UK and
yeah, yeah. So the easiest way to remember it is that, like, the UK has, like, a more subjectivist approach. Like, it's not 100% subjectivist. Like, there's still a temporal limitation. So, like, not everything falls within the of attempt liability, but the UK will establish attempt liability earlier on than the Netherlands will. And like the Netherlands is just very, 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 very objectivist. Like the Netherlands, you have to like almost already be committing the crime in order for them to establish attempt liability.
And when they say like a subjectivist will like think this and that, in the book it says that a lot.
It says
I mean, like, I think we should just get and in the lecture, they don't really emphasize the UK and the Netherlands, at least
Yeah.
for out here.
yeah, I mean, like on the exam, if they ask you about attempt liability, it'll more than likely be in the Dutch system, and so then it'll be a very objectivist approach. And then, like the thing to know when you're comparing like the subjectivist approach versus the objectivist approach is the subjectivist approach is the like rationale behind that is that they like we're imprisoning people, we're punishing people, whatever, like we're doing that because we think this person is dangerous and or like culpable, so they carry a sense of guilt. And when we're trying to see whether or not the subjectivist would be able to establish attempt liability, we would be looking at essentially whether or not, I want to just give you the precise like phrase, but whether or not the action that this person has undertaken, like, is that evidence of this person's criminality or dangerousness or intent to commit a crime. And if you can answer yes to that question, then under like the subjectivist framework, you would be able to establish liability. And so the main result of the subjectivist approach is that liability is established earlier on. Whereas like with the objectivist approach, like the like why we're prosecuting someone, why we're imprisoning someone, etc., is because of the crime. Like it's really the crime itself that makes the system act essentially. And so when the objectivist like is looking at it, they're like, is this action, is it dangerous to a legal interest? And in order to like properly answer that, you would say like, is there an act of manifest criminality? And if there is, and like only if there is, would the objective establish attempt liability. So the result of that kind of theoretical framework is the objectivist like will establish attempt liability at a later point in time than the subjectivist. And like I said, like the Netherlands is very objectivist. They're like very, very strict, and the UK is not. Like they're just more lenient. They're a little more subjectivist. There's more room for like argumentation. Like in line with the fact that the Netherlands is a very objectivist approach to establishing attempt liability, like in the Dutch Criminal Code, Article 46, they have like preparation, and that's been criminalized in the Netherlands. And preparation is essentially like things that people do, actions people undertake in order to like build up to committing a crime. But because of the objectivist approach in the Netherlands, like would not be able to fall under attempt liability. And there's a few caveats, like you can only establish preparation if it's a serious crime. And you have to look at the acts and still be able to say this is something that someone's doing because they're like they are going to commit this crime. But like the Netherlands has that criminal provision because of the way that they interpret attempt liability. The UK like does not have preparation because they would just like include that in their definition of attempt liability. Depending a little bit on what the preparation is, it still can't be too far removed, but they would include a lot of that.
I was asking if like the perpetrator only say like I'm going to kill tomorrow, or only has the intention. I mean, can we establish that he is liable for attempt under the subjectivist?
No, because Like the basic thing for that is only actions are criminal.
Okay.
So just because someone thinks they're going to do something, until we see that like evidenced at least somehow by action, then it's not. It doesn't qualify as a crime. But intent, it is an important part of establishing attempt liability, because for attempt liability, you have to have intent. You can't have negligence. Or in the UK, you can't have recklessness. And this is like a really important rule and like nuance to understand, because so in the Netherlands, to establish like attempt liability, they'll accept any form of intent. So they'll accept direct intent, indirect intent, and then conditional intent, but they won't accept negligence. But in the UK, they'll only accept like, because of the way that they think about intent, and you have like intent, recklessness, and negligence. Like in the UK, they only accept intent, which means they only accept direct intent and indirect intent. And then conditional intent in the UK falls within the scope of recklessness. So the UK would not accept conditional intent, because, like, for the UK, it's recklessness, and they won't accept recklessness for attempt liability. Yeah, so that's like just something to keep in mind when you're establishing attempt liability, is what forms of intent do these systems accept, and can I establish that for the case at hand? Yeah, what I would definitely remember from this week is like more the objectivist approach to attempt liability, because that's like what they use in the Netherlands. But also that the Netherlands has preparation, because that was on the exam last year. Yeah. After that, like for part A, you guys looked at impossible attempts, and I actually really liked this when I learned about it last year. I thought it was very interesting.
Yeah.
And like what's really important with impossible attempts is just to like learn the systems separately. So, because if you start to go like cross system and compare them to each other, it gets a little bit confusing. But if you just learn that like the Netherlands has this and UK has this, and this like we're just not going to kind of compare them. I'm sure people do, but for the purposes of our course, like we're not going to compare them. It'll be easier. So like for the Netherlands, they recognize like relatively impossible attempts and absolutely impossible attempts. And if something is relatively impossible, like it means that under normal circumstances, it is possible and it is criminal. And therefore, the Netherlands would establish criminal liability. So, like, an example of this would be if someone wants to like hijack a plane, and that's their plan. They've got it all laid out, and like the plane right now is like on the tarmac. Tarmac is like they're still on the ground.
Yeah.
They've not taken off. So, and then this person, they go into the captain area, and they're going through all the attempts of the hijacking. But once they're like in the seat, they try and like turn the plane on, and there's like an issue with the engine, and then the plane won't turn on, and that like prevents them from completing the terroristic act. So this would be a relatively impossible attempt, because there's been this external circumstance, namely the problem with the engine, which prevents the action from being completed. But if it hadn't been for this issue with the engine, like it still would have been possible, because it is possible to hijack a plane, and it would definitely have been criminal, because it's a terroristic act. So that would be like a relatively impossible attempt. It's impossible because of like some external circumstance that's specific to this set of facts. Versus like an absolutely impossible attempt means that like it's really just impossible. Like there's no ifs, ands, or buts. Like it's just not happening. And if that's the case, like no matter what the person's intent is, like, or what they like thought was going to happen, if it's just like absolutely impossible, then the Netherlands won't establish criminal liability for it. But in the UK, this is different. So in the UK, they have like factual impossibility, for which they do establish criminal liability. And I think this is funny almost, but like factual impossibility is like, this is based a lot on the like perception of reality of the perpetrator. And basically what factual impossibility is like, if the perpetrator were to be correct about, you know, the way that reality existed and the way that these like facts would play out, then this action would be a crime and like would be possible. And then the Netherlands is going to establish like criminal liability for that. And an example is like, if someone believes, like genuinely believes, that you can poison someone with orange juice, and then every day they like give someone a glass of orange juice because they think that they're poisoning them, and eventually like they're going to murder them because of that. Like, we know empirically that this is impossible. Like, people do not die from orange juice poisoning, but the perpetrator like genuinely believes that orange juice is poison and this will kill someone. And if this were true, then what the perpetrator is doing would be a crime. So that would be like a factual impossibility. Whereas a legal impossibility, it is still based on like the perception of the perpetrator, but rather like it's not based on the perpetrator's perception of the facts, but the perpetrator's perception of the law. So if the perpetrator believes that what they're doing is illegal, but it turns out that it's not illegal, like even though they thought they were committing a crime, they're not criminally liable for that. It's not actually a crime. And this you can kind of link back to the idea of lex scripta, which is like that crimes crimes have to be written, they have to be put into law. And I mean, you can get a little bit loose because it's the UK system, so they're common law. So most of their laws are like, most of their crimes are written down now. But it's like, it's still the principle of legality. Like, you can't punish someone for something that's not a crime. And that's kind of what like legal impossibility is just giving life to. So if something is legally impossible, then there's no criminal liability.
Yeah, but it's kind of confusing. Like, what are the chances that we will meet a perpetrator who thinks like this?
Well, I mean, but like, for example, what if you like had just moved to the UK and you thought that like, or no, what if you no
Like, they don't know the rule basically, and they
Yeah.
think it's a violation.
yeah, like if you what's something that's okay, like what in America the drinking age is 21, and in the UK the drinking age is like 18.
Yeah.
So if you were to move to the UK and like be drinking and you're like 19, but you still think that the drinking age is 21, you're like, and you're drinking and you're 19 though, and you think, oh, I'm breaking the law because I am not 21. Like, you're not, because the drinking age is actually 18, and you're just not well informed.
Yeah.
Mostly people are well informed and they feel very liberated.
Yeah.
But hypothetically. Do you guys have any other questions on impossible attempts? Okay. So then we'll go to voluntary withdrawal. It's super easy to learn this in England because it's not accepted. So they just don't mess with it. And this makes a lot of sense if you consider like the fact that England has a more subjectivist approach to attempt liability, which means they believe more in like criminal law punishing people because the people are dangerous. And if you think about the fact that like even if someone voluntarily withdraws from a crime, they still like have demonstrated that they're willing to commit a crime and that they like are capable of that, so on and so forth. Like, they've still essentially demonstrated that they're dangerous. And that is, I actually don't know this, it's kind of a hypothesis, but I feel like that's why the UK doesn't accept voluntary withdrawal, because of the like underpinnings of their legal system. Maybe don't write that one in an exam, but now that I think about it, we're gonna scratch that. But anyway, the Netherlands, however, does accept voluntary withdrawal, and what the Netherlands does is they apply this like reasonable criminal test. So they ask themselves, like, if you were just like an ordinary, average, like reasonable criminal, would you feel compelled to withdraw from this crime? And if the answer is yes, then you're still criminally liable, because obviously, like, the reason you withdrew is not because you had a change of heart or you realized what you were doing was wrong, or something like that. There was like not a moral choice that you made. It's just that you were being reasonable. So you realized that there was something funny going on, and you no longer should commit the crime because like your odds of being caught went up, or circumstances were different, or whatever. Like there was a logical reason why you didn't commit the crime. Whereas like if the answer is no, and what am like a reasonable criminal would not have withdrawn from committing the crime, like, and you withdrew because you like had a change of heart, you grew a conscience, you were moral, something like that, then the Netherlands is going to say, well, we're not going to hold you criminally liable because you didn't actually commit the crime. And it's about this like standard of like what would the average criminal have done. And if you are just the average criminal, then they'll still hold you liable. But if you sort of like made a better moral choice, then they'll excuse your liability. This only, however, applies for like incomplete attempts. So you can't have like finished committing a crime and then been like, wait, I take it back, I withdraw. Like it's too late. You're like the crime is done. You could maybe excuse some liability if you took very like active and powerful like counterbalancing steps, but I would consider that like an exceptional circumstance, and not like I would be very, very surprised if they bring that up on an exam. So yeah, like mostly if it's a complete offense, then you don't qualify for voluntary withdrawal. This is all the material we have for part A this week, I think, unless the syllabus changed. Do you guys have any questions?
Explain the difference between incomplete attempts and complete attempts.
So, like a complete attempt, well, first of all, this difference is only important if we're talking about a result qualified offense. Because for a result qualified offense, you have to have like something has to happen in order for there to be that crime. So like homicide is an example of a result qualified offense. Like a person has to die in order for there to be a homicide. And we know that like a homicide is complete when the person dies. A homicide is not complete when the person doesn't die. Or like, for example, like a robbery is not complete if you don't actually like if the police walk in and you're like about to leave the house, with the TV, but you didn't actually get all the way out with the TV or whatever, then bit of an unsuccessful robbery. You didn't actually accomplish your goal. Yeah, so like it's complete essentially if it's finished. If there's nothing else to be done to like get to the result of the crime. And it's incomplete if there is still something else to be done to get to the result of the crime. For conduct offenses, like it's the conduct that is criminalized. So this like this distinction doesn't apply, and you can't really withdraw from a conduct offense. I mean, yeah, like drunken disorderly conduct is like a conduct offense, and like as soon as you start acting drunk and disorderly, you fulfill that offense. And once you stop, like you just like the conduct just stops, but that doesn't mean that you've withdrawn because it's a conduct offense. This is a bit circular, but yeah. And then just for the recording, because Amelia, in her email, so like, I'm gonna hate that I made that face on video. I want to back. In your email, you asked like, when do we know when to apply the subjectivist approach versus the objectivist approach? And I did mention this like in the beginning, but just like so it's clear and explicit. You apply the subjectivist approach basically if you're working in the UK legal system, and you apply the objectivist approach if you're working in the Dutch legal system. And that's when you know when to apply which, but you only apply one to a question.
But if it is stated in the question that we need to apply both the approaches, and then like one of the approaches doesn't really fulfill, it's still liable, right?
Well, if there's a question and they're like, please apply like both approaches, I would just give separate answers for each approach. So I would go through like my subjectivist criteria and say, based on this criteria, like the subjectivist would find this person to be liable for like a criminal attempt. However, if I look at the objectivist criteria, then and you go through the objectivist criteria, I would, because this is, you'll never have like an objectivist find someone guilty of a criminal attempt and a subjectivist not, because the subjectivist is always earlier.
Yeah.
So if there is a difference in result, it would be with the objectivist, and then you would be like, although the subjectivist would find someone liable based on the objectivist criteria, this person would not be liable because they're not far enough into the attempt. And then I would say, but these are different, like each system would have different answers if they ask you to examine both.
Oh, I want to make sure that voluntary withdrawal, it doesn't apply to an attempt, right?
I mean,
not only to the attempt, but also the preparation.
oh
Yeah.
yeah, it doesn't apply to preparation.
Yeah.
Because like voluntary withdrawal implies that you've already started committing the crime. Like you're already kind of like, you're definitely past preparation.
Yeah. Oh, okay.
Do you guys have any more questions or? Okay. And so, like, what is the main difference between establishing intent for attempt liability in the UK and the Netherlands?
For establishing attempt.
Well, intent for attempt liability.
Is that in this week? Is that this week okay?
Intent for attempt liability? Yes, I mean, because you don't have to go through and tell me what all, you don't have to say what all the forms of intent are, but there's like one specific difference that is important to know.
I'm so confused. Yeah. You know?
So the main difference is that in the Netherlands, like they will accept conditional intent for attempt liability. So the Netherlands will accept all forms of intent: direct intent, and indirect intent, and conditional intent. And in the UK, they only accept intent, which means they only accept direct and indirect intent. And they don't accept recklessness, which means that they don't accept conditional intent. Mm, mm. So then I would say we could do like a 10-minute break now, because then we'll come back and do part B and like an assignment question. Um, and then at the end, I have a few things to discuss in terms of like what I plan on doing for week 7, and then as well as like when we're going to do the tutoring session next week. So yeah.
Oh, by the way, I want to ask for the date because it's hard name. Do you know what it means by principal penalty?
In what?
It's in Article 46 Dutch Penal Code for preparation.
Can I read it?
Yeah. Uh, maximum principal penalty.
It just means like the
The most severe? Or
like the like no, it means like main penalty. So you look at the penalty for the main crime. Like if you've been charged with preparation for homicide, like what is the maximum um, penalty for homicide, and then you have that. So it just means to look
okay.
at the punishment for the main crime.
Oh, okay. Great. So, like, for example, the maximum, the penalty is 10 years imprisonment maximum. Then I will.
Mhm. Yeah, well, like, yeah, if the penalty for the main crime is 10 years,
Yeah.
then the penalty for preparation would be 5.
Okay. Oh, great.
Thank you. And I have a question about 9 years. I read somewhere that something about 8 years to start.
8 years for.
It was like, I don't know, I think it was like to be considered something.
Oh, well, I think because so preparation only applies to serious crimes, and I would probably double check this with the lecturer, but I think serious crimes in the Dutch legal system are crimes for which you can be imprisoned for more than 8 years. But I'll double check that in my book actually. But so I think we should take our break, and we'll be back in like 15 minutes, and we'll move to part B and all that good stuff. for part B, you guys had découvert. I don't speak French, so that accent is gonna be. I know. And then Colosa and Lala, right? Okay. Um, so Découvert, I really liked that case. I thought it was super interesting. But there are quite a lot of rules for it. But I feel like they're all like intuitive. Like because so Découvert, basically what it addressed, it was under Article 6.1 of the European Convention. And basically what it established and sort of spoke about was the fact that like under the ECHR, you have the right to an impartial trial. And an impartial trial is basically a trial that is like free from outside considerations, so the judge is deciding your case based on the objective like facts and circumstances and applicable law of your case and not like anything else. And so what Découvert said was that when the European court goes through to see whether or not you've actually had like an impartial trial, it's going to consider a few things. So firstly, it has to assess the like legal context of the domestic system. And when it looks at that, it wants to see like what role does everyone play? Does everyone have a specific role? Is that defined? Is that clear? And then also like, are there functions that overlap? Is there anything where the court's looking at it and is like, ooh, you know what? This is maybe a little bit fishy. Like we think this person is doing too much within the criminal justice system. And really like what the court is looking for under the first step is it's trying to see if there's anything very explicit that is cause for concern with impartiality. And what that means is like, if you're a judge, like you should be assigned to a case randomly, you just get put on the case and you decide the case because it's your job. So if someone has asked to be put on a case or been moved to decide a case or anything like that, where they didn't like randomly get this case, somehow it's come onto their docket and there's just like one too many steps. Do you know what I mean? There's something a little bit sketchy about how that came about. Then the court's going to be like, like why? Because if you don't care about the outcome of the case, like more than the other judges, like you care that the law is applied correctly and that there's a like fair and just outcome, but like that's it, then you're not going to like request to be put on a case. Like, there's not going to be any changes made. And if you do, then that's kind of an indication to the court that something is not like as it should be. But the first step is actually like not that big. The main test in Découvert is under the second step, which is you have to test for like impartiality on a personal level, so subjectively, and then like externally or objectively. And the personal impartiality of a judge is always assumed. Like the court does give that leeway and sort of like benefit of the doubt to judges. So if they ask you or if someone is trying to like claim that a judge's personal impartiality is like corroded or corrupted, there has to be something in the facts, there has to be some evidence that proves that. And if there's not, then we assume that there is that personal impartiality. The external impartiality, we do like test for more and we really like look and critique to see if it's there. And like the main thing and the whole context of the Découvert case is that in like continental European like criminal justice systems, there's this role of the investigating judge. So, and this has changed like as things have developed and really in part as a result of this case. Previously, it was that like a judge would be assigned to a case. Like once the police had done like a preliminary investigation, a judge would be assigned and then they were responsible for like the like more in-depth investigation. They had to establish the laws and legal practice and like more facts, and they would also do interviews and all these different things. So they were very active in this investigative role. And then what was happening is the judges, they would be the investigative judge, and then they would also be a judge at trial. And sometimes they were a judge at trial, like, and they were the only judge. And sometimes they were a judge at trial, and they were like, it was like a group of 3 judges. And so it was them and 2 other judges. And that was the Descouvert case. He had been like, I think like his investigating judge also sat at his trial. But and this, the European Court says, violates your right to an impartial trial. So regardless of if the investigating judge is the only judge that sits at trial, and that would just depend on the legal system and circumstances of the case, whether it's a bench of 1 or 3. That's not really the point. But whether like the investigating judge is your only judge that sits at trial, that obviously will violate impartiality, because then they're just like, they're judge, jury, and executioner, and we need those processes, those steps to be different. But even if he is one judge among 3 judges, this is also a violation of the impartiality, because the court considers that he is going to like have more influence on his colleagues, and he's going to like, and the thing is, like, he'll have done the investigation, he'll push things, he'll like work to persuade, I mean, theoretically, he'll work to persuade his colleagues that the investigation is good, and that like this person is guilty. So if the investigating judge sits as a trial judge at all, then the impartiality of the trial has been compromised. Because also, like, and this kind of ties into the last point, so I'll hold on. But like, there's other external factors that can like violate someone's, like, the impartiality of a trial. So like, I mean, obviously, if there's been like a bribe, if someone seems to be like deeply connected to a political party, and now they're like deciding a case on this political party, or if you're related to the person that's on trial, like, there are other external factors that can violate impartiality. And usually, like, if you read those in an exam, it'll be things that we like associate with someone's judgment being clouded. So that should be quite, like, it should really be apparent to you. You know what I mean? That is the case.
Yeah.
But Descouvert like specifically addressed the investigating judge, because that was a big issue in the continental systems at the time. But the last thing that they mentioned in step 2, and that kind of blends into step 3, is that you have to consider the position of the accused who like is on trial. And if this person knows, that they've been under investigation by this specific judge, and this judge has been undertaking all of the like more coercive actions that are associated with investigations, like still within the limits of the law, so nothing bad, but just investigations are a little bit coercive in general. And now he's like sitting at your trial, like, as the accused, you're not going to have faith that you're receiving a fair trial. And this like really ties into the last step of the Descouvert judgment, which is that like you have to like assess the way that the trial appears to people who are watching it and to like the public, because there's this quote that they give us in relation to Descouvert, which is like, justice has to be seen as well as done. And so it's like, part of the thing of a criminal justice system is people have to have faith in their criminal justice system, and they have to trust that like when they're in front of a judge, the judge is going to deliver a fair, impartial, respectable, accountable judgment. And so like even if we don't know that the judges like that his impartiality is compromised, if it looks that way, if it seems that way, we just have to be on the edge of caution with that. And we have to do everything we can to make sure that the public still thinks there's this impartial trial. Because we don't want the public to lose faith, like, in the criminal justice system. And that's, like, what the last step of Descouvert basically says, is, like, maybe we don't have the evidence to support that the impartiality is compromised, but we think that it looks that way. And therefore, we're going to say it's not really in line with Article 6. And there's not like that's just kind of a gut feeling, I would say. Like if you're just looking at the case and you're like, yeah, maybe I can't prove everything, but looking at this and looking at this and looking at this, it's still not at the standard. We have two other rules for découvert, which is that like higher courts can repair a violation of the lower courts. So if there was a trial that wasn't impartial, but then you go to appeal and then you get like an impartial trial and potentially the charge is changed or dropped or whatever, then you no longer have a claim before the European Court. And then if like the member states cannot like invoke as a defense the fact that their legal systems work this way, because that was something that like a lot of the continental, well, Belgium, but the continental systems tried to say is like the investigating judge, it's part of our tradition, it's what we do, like this is the way we run our system. And the court was like, well, sure, great, but like no, like you still have to meet our standards. And you can have an investigating judge, but then that investigating judge can't be the one that sits at trial. So yeah, but maybe it's not the investigating judge, it's another element where the state is like, this is just how we do things, but that's not actually a defense.
Yeah.
The next case that we have is Colosa v. Italy, which is just about Article 6. And it's the right to be present at trial. So this is an implicit right. It's not explicitly stated in the article itself, but the court has said in order to fulfill your other like Article 6 rights, you really you should be present at trial, and you have a right to be present at trial. And you don't normally have to know the facts of the case in order to be able to like understand the case and the rules, but I think it is worth like kind of remembering the facts of Colosa because they are quite illuminating. Yeah. When you're like thinking about the rules, because the rules for Colosa is that like if someone is not present at their trial, then the authorities like they have to be able to establish due diligence in attempting to contact the person and letting them know that there's this trial and they're expected to be present at the trial. But in addition, like if the authorities claim that there's a waiver of the convention right to be present at trial, then this has to be unequivocal. So it has to be written, or the person can be consciously absconding. Like if the person is fleeing, if someone's gotten on a flight to like Fiji and then refuses to come back to the Netherlands for prosecution, like then they've waived their right to be present at the trial. They've chosen to be at the beach. Like honestly, I get that, but they have sacrificed their rights in that case. And then there has to be the possibility of a retrial. And when you look at all of these, like they do all have to be fulfilled in order for a trial in absentia to be compatible with Article 6. So the authorities have to have exercised due diligence, there has to be really an unequivocal waiver of the right, and there has to be a possibility for the retrial. The concept of due diligence and the unequivocal waiver of the right, they go a little hand in hand, because if authorities have like absolutely exercised every due diligence and we know that the person knows they're expected to be at trial, then essentially you can establish that this person is consciously absconding. But if the authorities have not exercised enough due diligence and we don't know that the person knows they have to be at trial, that's when you would have to say, well, no, we can't establish they're consciously absconding, and therefore I need a written document that says they're sacrificing this convention right. And like these are really easy to remember if you remember the facts of Colosa, because the Italian government just did none of this. Like they did not meet due diligence whatsoever. They like sent one letter or something to this guy and was like, hey, you have this trial, and then they didn't hear back, and they were like, it's okay, he knows, it's fine. And like if they had the thing is he'd registered his move at the DMV / administrative office or whatever with the Italian authorities. So if they had called up a colleague and been like, hey, I need to contact this guy, they would have gotten like the right.
Yeah.
It was so, they were so nonchalant.
Yeah.
And then they were like, we did enough. And the court was like, you did not do enough,
Yeah.
first of all. And then they were like, he waived his rights, and the court was like, he did not waive his rights because
He did
like,
not.
yeah. And then he requested a retrial because of all of this, and Italy was like, no. And the guy was like, now I'm going to the European court, and the European court found in his favor. So like, it was not Italy's best moment. But yeah, I mean, all of these rules were really developed because of the facts of that case. So it's easy to remember if you kind of can remember the whole picture. In terms of the Lala v. the Netherlands case, it deals with Article 6.3c, and it basically says that, like, it's not actually in response to Colosa, but to me they established kind of opposite rights. So Colosa says you have the right to be at your trial, and Lala says, yeah, but you have the right to not be at your trial, like if you don't want to be. And he said, essentially, you have the right to be represented at trial, like by your lawyer, if this is what you decide you want. Because, like, and the whole rationale behind this is that the court thinks, like, someone's absence from trial shouldn't, if they're aware of it and whatever, it shouldn't affect their ability to present a defense. And you can still present an effective defense if your lawyer is allowed to be there and present it for you. So it is really still about, like, ensuring the fairness and effectiveness of the trial. And, like, the only other thing that Lala said really is that the domestic courts, like, they have to accept this and they have to allow the defendant to do this. So there can't be any, like, procedural like roadblocks that they put in the way that are unnecessary and, like, just make it more difficult for someone to do this. And yeah, that's basically all Lala said. Love that their name is Lala though.
Yeah. It's easy to remember.
Yeah. Yeah, but the cases this week were not that bad. They all have to deal with Article 6, so that kind of, like, makes them easier. I'm sorry? For Lala, yeah, it's Article 6, 3C.
I want to ask, in the exam, would it be possible for them to actually ask you to analyze the case that constitute of two different cases that we learned in different weeks? Like, for example, Lala and also the Uster.
You mean, Uster.
I mean,
Well,
I just pick random cases, but yeah, for example, like that. So not in the same week.
Yeah. I mean, the answer is yes, and it's because, like, they're all kind of different questions of law. So, like, for Usturk, it would be, you would have to, like, you're establishing that something is or is not a criminal trial, and basically that means you're establishing, like, the jurisdiction of the ECHR, of the European Court. And then if they're asking you about law, then that's, like, a specific infringement of Article 6. And so, yeah, like, I don't know that Lala and Usturk is precisely the combination they'll go for.
Yeah,
But for example, like, they did something last year with, like, Khan and then, like, Allen. So with, like, listening devices and, like, articles like 8 and 6 together.
Oh yeah.
Or especially if they decide to test you on, like, Yalo and Gafkin, then they'll combine Articles 3 and 8. But Article 3 is really easy, because if there's anything in the facts that indicates to you there's, like, some form of inhumane or degrading treatment, then you can establish it. Like, the steps for that are not really difficult. You just have to know that you're establishing it under Article 3, and then you apply your rules. So that would be like Yalo and Gafkin. Maybe No, Nimitz is not about Article 3. Yeah,
but it is possible. So
yeah, it's definitely possible. Mm, do you guys have any other questions on the Part D material for this week? Yeah, Part B this week is not that bad.
yeah. Plus the cases, I think they're not that long. Not as long as week 3 at least.
No, but week 3 is the worst for Part
yeah,
B.
yeah.
After that, it gets much better.
Oh, how do you answer like in with the IRAC method in the analysis part, like whether like you need to apply objective and an objective test, right? Yeah. How do you
Mhm.
apply it to the case?
For Part A.
Part,
Well, if
because,
it's Part B,
from the I think from the Cooper versus Belgium,
mhm.
yeah. We were told that we need to establish the subjective and objective.
Yeah, so the subjective impartiality is like the personal impartiality of the judge. So that impartiality is assumed. Like, unless there's something in the facts that says, like, the judge, like, that indicates to you the judge, for personal reasons, like personal thoughts, personal preferences, whatever, is not able to be impartial, then you can just say the the European Court assumes the subjective impartiality of the judge. And then when we talk about objective impartiality, we look for external influence. So, was he an investigating judge? Does he have like like ties to any organization or association or something that would mean he is more likely to decide a certain way? Has he been like in contact with like certain parties? Like, does it seem like there's a relationship there that is not, you know,
So pretty much
up to
the
par
same thing with part A.
of like objectivist versus
Yeah.
they're they're very different
Really?
because
Okay.
like subjectivist and objectivist in Part A is about attempt liability. So
Oh right. Yeah. 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 I just remember that.
yeah, and this is about just sort of
The
in
judge,
in what ways might the judge be impacted by something. Mm-hmm. Mm-hmm.
Like, is that how it seems that says about poverty?
Well, no, because like the so okay, like the accused is really most important when we're talking about an investigating judge, because the accused will have like dealt with this judge throughout the course of the investigation, and he'll know that this person was the investigating judge. And like the idea of, considering the public and whether or not justice like appears, for example, as if it's being done. The investigating judge is not, it is important, but it's not like so directly correlated. Like the third question, insofar as whether or not the public feels and can like have that faith in their criminal justice system, is like more abstract. So it's like it's more like, is there okay, because like if you were an investigating judge and now you're the trial judge, like really, if we're being honest, like you can't be impartial. You have too many assumptions going into it and too much like pre-existing knowledge to be able to objectively decide the case. And so in that way, like we can actually like evidence and prove that the impartiality of the trial has been compromised. Whereas like and that is like, and when I say, you know, consider the accused, like that's more just like one of the reasons, like it's not like the most important thing actually, but it's just like something to keep in mind. Whereas like for the third step, and when we're considering like how does this appear and what does this look like, when we get to that step, it means that we are not actually able to prove based on like evidence that the impartiality of the trial like has been compromised. But there's something about it, there's a specific characteristic and circumstance which still looks like it's been compromised. And so for example, like let's say that
Even the slightest doubt, you can have it.
yeah, because we need people to have like faith in the criminal justice system. And so like mm, okay, let's take like a real life example. Like well, actually that's so okay, like let's say you were a judge in the US right now and you were like going to decide the trial of someone who has been charged with like being involved in the January 6th insurrection, right? And then it comes to light that you like made a donation to like Donald Trump's like political campaign during the 2020 election. We can't prove that you're not impartial because you just made a donation. Like there's no you it's not like you actually worked for the campaign or had like a direct connection or like that you you know that there's really any relationship other than this like monetary donation, right? So I can't prove that you're not going to be impartial when you decide this case, but it doesn't look good because of like the context and which, to be fair, has not been established that Trump played a role in inciting the January 6th direction. Yes, but I mean, come on. So the fact that like you made this donation to him in 2020 like makes us feel that you're not going to be able to be impartial, but we don't know, but we feel, and that is like something that would be caught in like step 3 because it's like a feeling. Yeah, so it's more abstract. But yeah, if you guys don't have more questions, we're going to do another exam question. Do you guys still have the exam that I sent last time?
Yeah.
Okay. So let's do question. question like E, but like only the latter question. Like
For part B,
yeah, so for part B, like question E, because the other yeah, for part A, the one question you guys learn next week. But not like the question that they have about like immutability and immediacy, we're skipping because you guys don't learn that this year. So just the one where it says the applicant complains that the camera surveillance has involved like unlawful intrusion into his private life. Yeah. So, what are our thoughts?
I mean, the issue here is whether there is a violation of Article 8 of CSR,
Mm-hmm.
and then the rules would be from the rule Article 8 of the CSR and two cases from week 2,
Which cases?
Khan and I forgot the other one. Um, Khan and Nimitz.
Okay, and what rules did Khan and Nimitz establish?
Whether it's fall under the scope of Article 8, and then in accordance with law and necessary in a democratic society, would you need to establish that as well?
Well, yes, you do have to establish if an Article 8 infringement is in accordance with the law
Yeah.
and in pursuit of a legitimate interest and necessary in a democratic society. But that's a result of paragraph 2 of Article 8
Oh,
and not of a case law.
okay.
And the rule that like we're establishing if something criminal trial or not is established in Uzturk. But you actually, Khan and Nimitz are the cases.
Okay.
But what are their
Um,
rules?
so does the interference fall within the scope of Article 8?
Well, that's the rule in Uzturk.
Oh, that's not them.
No.
Okay. I forgot it.
Daniela, do you know maybe? So let's start with Nimitz. Yeah. So I feel like I know why you're thinking of Uzturk
Yeah.
when like wait. This could be my mistake. Like you're saying whether or not you're saying one of the cases establishes whether or not something falls within Article 8.
Yeah.
Okay, that's my mistake. That's Nimitz.
Okay.
That's
yeah.
on me. That's on me.
I was thinking like,
Okay. Yeah. So Nimitz establishes if something falls within the private life and what like
yeah.
but what does Nimitz say? Like how do we know if something falls in private life? What was the actual result of that?
It's a little blur in my mind, but
Because we know we've always known that private life means like for example like the home and family and stuff. Yes. So Nimitz said that even like professional spaces will qualify as private life and that they like are also within the scope of Article 8. And what about Khan? Like what rules do we get from Khan?
I honestly forget.
So what article is Khan on? I mean, it's just always the first question, and it helps refresh memory and stuff.
Yeah, Article 8.
Okay, and do we remember like the situation in Khan, like what specifically happened, or So Khan basically established that the domestic law, like, it has to be sufficiently clear and precise. And then in relation to Article 8, it established like what procedure we have in place if like evidence that was gathered in infringement of Article 8 is used.
All right. Yeah. Yeah.
So if there was evidence that was gathered like via an infringement of Article 8, the applicant like must have had access to an effective remedy, so he must have been able to contest the usage of that evidence and the admissibility of that evidence to trial. The trial court like should have been made aware of the fact that the evidence was like gathered as an infringement of Article 8, and that needs to impact the way that they deal with the case. And then also we know like that the conviction itself needs to be based on more than the evidence that was gathered in infringement of Article 8.
Oh. Okay, I remember.
So if we take these rules and we apply them to the present case, what do we find?
Well, first of all, I think yes, it does apply. It does falls under the scope of Article 8.
Mhm.
And do I need to elaborate more on that?
Well,
Like,
you can just say, yeah, you can just say because the units, like expanded it to professional life, then we know that it falls within the scope of Article 8.
oh, okay. And then for that's all for movies, right?
Yeah.
And then for cut, there are we have to apply like all 4 or 5 of the criteria. Like, is the specific law compatible with the domestic law, rule of law, rule of law?
No, I mean, you can just say whether or not you thought like the rule is sort of in line with the rule of law.
Um,
Because that gets applied in paragraph 2 essentially when we consider if something is like in accordance with the law, in pursuit of a legitimate aim, and then necessary in a democratic society. So we can say like the use of the listening devices, um, we know like is an infringement of his private life because of the rule we have in Nemitz that means that private life also extends like to like his office and stuff. And if we consider then whether or not that like infringement is justified under Article 2, we have to have mind to like the criteria in Khan. So is it in accordance with democratic society? And Khan says this. Is it in accordance with the law? And Khan says this about the standards for the law. So then, yes or no? Like, are those standards met? And then once we say it's in accordance with the law, it is in pursuit of a legitimate aim. That normally never goes. But then we can say we also have to consider if it's necessary in a democratic society. And when we consider that, then we have mind to the second, like, rules from Khan, which is like, even though the evidence was used at trial, like, did he have the right to contest that? Was the judge made aware of that? Was it the only evidence? Then that is like kind of like necessary in a democratic society, whether or not that requirement is met.
I don't see the fact that here in the case the public prosecutor like put the surveillance with the I forgot what it's called, like with the because they get the permission from the court.
Mhm.
Yeah, they didn't ask for it, so I would say it is violent.
Mhm. Yeah, so they didn't get permission from the court.
Uh,
They also carried on their surveillance for 6 months, which is
non-stop, yeah, 24 hours.
which is not really like that's very extreme.
Yeah.
So in general, we would say that there has been a violation of Article 8.
Okay, so I mean to conclude, like in the analysis, we can just say like, yes, it does fall under the scope. It does fall under the scope of Article 8 CSR,
Mhm.
and then because of the surveillance, they installed there nonstop for 6 months, and including in his private office, which is an infringement to his private life,
Mhm.
and they didn't also ask for the permission. They didn't ask for the court's permission to do so. Therefore, there's an
Yeah. Yeah. Well, there's an infringement, and it's not justified under paragraph 2.
oh, okay.
Yeah. Okay. And then I also wanted to essentially like discuss with you guys. Why do I have it here? When are you guys free next week for the session? Because Saturday is Christmas, so it's
Yeah.
not gonna be
Yeah.
then, obviously.
Well, we didn't have class. Do you have class on the 23rd? We do. I think we do. But in the morning.
Mhm.
So I feel like I will be available after the class, or like around 12. But I'm not sure if the others are available at that time. So would it be better to like create a desk speaker? Yeah. Or
Yeah, I mean, I think Thursday is a good day.
but I'm not sure whether the other will be free on that day. Because I know some of them are going back. I play
Yeah, I'll ask in the group chat and I'll see what everyone
yeah.
says.
Yeah.
It'll be held online next week because I'm
Yeah.
not in Carnegie.
Yeah.
Yeah, so okay, so I'll ask in the chat when everyone is free and we'll see what they say.
But definitely not on Friday or Saturday.
No.
Yeah. Yeah. No. I can't.
Mhm.